Okay. Oh, I actually can see some of you. So good afternoon once again. Happy Friday Eve. My name is Clotel Drakeford, as you know, and I'm a graduate of Albany Law class of 2011, and I have been actually on my own as a solo practitioner on and off now for about 6 years. I started out initially with the public defender, but it was a part-time position. So I actually had to kind of drum up some business and figure out a way to supplement my income. And I hung out a shingle at that time. I did have some stability through, the part-time position. So I was able to kind of start understanding the world of practice as a solo, but get the benefit of course, still being a practitioner in an organization initially. So let me tell you about, we're going to move into our presentation. And let me tell you about my firm. The official Drakeford Law Offices, PLLC, was formed in 2017. That's when I actually decided to go ahead and create an entity and no longer operate kind of in a solo practitioner capacity. So my firm is a boutique firm, and I specialize in labor and employment matters, which hinges primarily in the public sector, but I also do handle some private employer work as well. A part of that practice has kind of turned into a niche where I'm often retained as neutral, impartial attorney investigator, not serving in an advice and counsel role, but I'm actually investigating allegations of, let's say, misconduct in the workplace, allegations of workplace violence, retaliation, harassment, discrimination, those sort of things. So I have been retained to do the fact finding, if you will, in those situations. I also handle criminal defense matters based on my prior experience as an assistant public defender in Columbia County. And I am now building a practice involving civil rights matters involving police misconduct. So we're talking excessive force, we're talking false arrest, things along those lines. I am co-counsel in a current case pending in the Northern District here in New York. And I am not lead counsel. I'm kind of cutting my teeth, if you will, and learning the ropes of that practice. I've also done a good deal of mental hygiene, Article 81 guardianship proceeding work, where I'm either representing a party, a petitioner, or a respondent in one of those proceedings, or I've been on the assigned counsel panel where I'm appointed as a court evaluator to serve as the eyes and ears of the court and do the investigative, once again, kind of fact-finding work on behalf of the court under the Article 81 MHL framework. So that's the nuts and bolts of my practice, but I'm telling you about it so that kind of during the presentation, I can give you some real-time examples as to how the way I practice law is relevant into your considerations for what you're going to do potentially in opening up your own practice. I do not essentially have a transactional practice. My practice is more so advisory in a counsel role, or so a litigator, or I'm doing fact finding and again investigative work, excuse me. So I'm billing by the hour essentially. There are typically no sort of flat fee arrangements unless it's involving a criminal situation where I'm taking, of course, monies up front. We'll work against that. If we need to replenish, we'll then supplement it at another time. So for those of you who are contemplating going into the other world of practice where it may involve, let's say, real estate or wills and estate planning, typically that work is done for a flat fee. And we'll get into the details why this may be relevant and how you're kind of strategizing and thinking about, if you're going on your own in the future, how to think about these issues. So I wanted to, we talked about this earlier, I wanted to make sure that you do at some point take a look at the checklist that will be provided. It's really exhaustive. I can't take credit for it. It was prepared by the Law Practice Management Committee of the New York State Bar Association. I stumbled upon it earlier when I went out and on my own and hung a shingle, but it really covers everything. It's I do front and back to save paper, so I would say it's probably about 6 pages or so, just covering every soup to nuts, everything that you should be thinking about. And I haven't even accomplished everything that's suggested and recommended on this list for my practice. So it's really exhaustive, as I said. Now, getting into things that you ought to be thinking about in terms of practice areas and how to figure out, what would be the best way to go if you're still early in your career, most people, I think it takes about 5 years to get kind of a real sense. You may know going into practice, I really love X area of law, but then you find after a while, maybe I want to do some other things, or maybe not so much that. I believe it or not, I actually sold real estate in law school and worked my way through law school. And I just knew I was going to have this amazing, thriving real estate practice. But I actually decided, you know what, that's not really what interests me. It was for me too humdrum, quite honestly, reviewing contracts all day, having to follow up, of course, and get the deal closed. It's, of course, a volume-based practice. You're not billing by the hour. You're setting a flat fee to handle the matter. And so the time that I was spending to get the deals to close, for me, it just wasn't as gratifying. I started to try to figure out what else can I do, and I started exploring and moving into other areas. So the first bullet that you'll see in deciding what practice areas to offer that you should be considering would be, what are your interests in the law? That should be driving, the decision-making process, of course. But I also humbly offer that you may want to think about your personality, your strengths, your weaknesses. The practice of law, I'm now 7 years officially in, is really a people-driven and relationship-based profession. So, of course, the attorney-client privilege is, sacrosanct in terms of the relationship and the way in which counsel and the client, of course, have that rapport, and should be, of course, a level of confidence and a level of trust. That's the same with your adversary, your co-counsel, your colleagues, your counterparts, depending on, your practice. So, for me, I'm not going to do well having to stay at my desk all day, reviewing documents only, reviewing contracts, signing off, making sure that a transaction is going to be completed. I need to be at times away from my desk. I need to be, if you will, out in the field. I need to be potentially, believe it or not, I enjoy if I have to visit a client in the jail cell, a jail cell situation. I'm okay with that. I could be at an employer site interviewing witnesses. That's my personality. I can't, after a number of days or hours, feel good about I'm stuck in an office space looking at documents all day. So think about that. But you could be completely the opposite of me and feel like that's nothing at all that would float my boat. So then, you know what? Take that into account and how you decide to structure your practice. I also think that you ought to be contemplating the return on investment of your time based on your expertise. Like I referenced in the top of my discussion, for me, the real estate practice was just not as lucrative of a practice unless I really delved deeper into it and wanted to have a lot of volume. Because spending the time on one transaction or two, I usually had 3 or 4 going at a time. But the time that I was spending in preparing documents, reviewing contracts, following up, with my sellers or my buyers and opposing counsel, what have you. You don't necessarily have opposing counsel in a real estate transaction, but anyway, on the other side of the deal, I'm gonna spend maybe 10 hours, but I'm gonna charge a flat fee for that. So in other areas, of course, I'm billing by the hour for everything that I do. The other work simply overtook the value for me in terms of what was more lucrative. So I decided, you know what, let me cut out the real estate. So think about, how much time it may take to conclude a matter once you're engaged, and what your financial situation honestly is. Another area, of course, that you should be considering is the complexity of the legal issues, because if you're starting out, your time is, of course, precious. So if it's going to take a lot of work to conclude the matter and you're expecting a fee at the conclusion of the matter, you've got to be able to figure out when you're on your own, how am I generating cash? How am I going to still be able to meet my obligations while this matter is pending for resolution? Some things, of course, you get your retainer, you set it up, you bill against the retainer. The client then, of course, is expected to replenish. But other times, the arrangement is upon conclusion. So there's flexibility there, but these are things you should be thinking about in terms of how you're structuring your practice. Last but not least, of course, is overhead for covering the costs of the representation. I bring that up for those of you who are thinking thinking about going into the world of, let's say, malpractice, medical malpractice defense, or perhaps, or more so plaintiff side. This is really more so a sticking point there. In the civil rights work that I'm doing, it's a contingency case. There are no fees unless I am able to successfully obtain a recovery on behalf of the clients, correct? So therefore, you're having to underwrite everything. This is litigation. This is volume, document intense. There's discovery. You've got to carry the heavy load and do the heavy lifting, rather, in order to be able to conclude the matter, bring it all the way, of course, if it doesn't settle to trial. Your plaintiff clients are not going to be able, more likely than not, to underwrite the cost of representation. So again, these are things that you've got to focus on in how you're structuring your practice. That's why I've chosen to kind of mix it up. For me, the best way was to be able to bill by the hour and, of course, set a retainer arrangement. If I had more time, I would love to get into, of course, some of those ethical issues that come into play when you're dealing with all this stuff, but maybe another time we'll be able to build on what we're doing now and be able to go into the ethics of it. But I will touch on that here and there. Now you're going to want to be thinking about what type of practice. Once you've figured out your areas, do you want to do like I did initially? Do you want to simply get business cards? You're duly licensed, you're ready to go. Essentially, you're a sole proprietor, solo practitioner. No entity, you're simply taking cases, appearing, doing the work, but you're on your own. I decided later on, you know what, I'm doing a lot of work here. Potentially, I could find myself, you never know, dealing with a dispute, or a client's not happy. I don't want to have to personally have to deal with liability issues. Let me establish a formal entity so that we can kind of do some risk apportionment, if you will, and I'm not going to give you any sort of advice as to which way to go. That's where you're going to want to obviously consult with counsel, a colleague that specializes in those areas, or of course a professional accountant. But you got to do that anyway, because you're going to want to understand what your tax implications are. You're going to want to understand, if you're creating an entity, what are your filing requirements, what are the associated fees. You got to publish, create articles of an organization. So you at this point, these are things to be thinking about. Another important thing that I think you've got to always keep in the back of your mind is, can you comply with the governing rules of professional conduct? And I touched on that again in terms of ethical considerations. If you're not someone who wants to deal with money, you may not want to go on your own. You may want to have a partner, you may want to stay where you are, because you're going to be a fiduciary. You're going to be handling client funds. You're going to have to establish an escrow account or IOLA account. And you've got to monitor your statements. You've got to make sure the books are balanced. And you can, of course, if you're able to hire, staff to be able to take on those responsibilities for you, you certainly can do that. But ultimately, the buck stops with you. You must oversee all of that work. If somehow something gets misplaced, you're on the hook. You can understand that there could be disciplinary measures that, could result in suspension or even disbarment if there's a notion of theft or some other impropriety. So you really want to make sure that you're able to take on the responsibilities of ownership and practice that complies with the governing rules of professional conduct. When you're an associate at a firm, you don't have to think about those things. Or if you're working for an organization, a public organization, none of this is relevant. But if you go out on your own, it becomes critical and very relevant. So one of the things that we're going to talk about that is important, because I've already touched on it, but you can see in my slide here, professional liability insurance, also known as medical malpractice insurance. You need it. You got to have it. It's just like that umbrella on a rainy day. You want to be able to pull it out. Sometimes things happen in cases no one expects to make a mistake, but they happen. And you want to be in a position to have coverage. You don't want to have to defend the matter, come out of your pocket personally in order to respond and resolve it and deal with it. So it's just like a rainy day. You would rather have that umbrella and not need it if it doesn't rain, but if it does in fact rain, you do have it. And when you're starting out, it's actually pretty inexpensive, because guess what? If you're a newly admitted attorney, you're more likely than not don't have a basis to worry about having a dissatisfied, grumpy client who's going to potentially allege malpractice. So the premiums are fairly low. Now we're going to move on to other considerations that are critical when it comes to having your own practice, which involves, of course, income taxes. I hope this is humorous. I say this to myself when I'm doing my work. I owe, so off to work I go. When you're on your own, you're getting paid a flat fee, whether it's cash, whether it's a wire, whether it's check, it ends up all being cash. You're not having taxes taken out the way your employer would normally handle that for you. You're the employer, you're the owner of the firm. So therefore, you must be prepared to allocate appropriately taxes for your expected contribution on those earnings. You would, of course, want to consult with a professional accountant or a tax advisor to understand what your quarterly tax payment obligations would be. You normally would project, certain, your first quarter you may not know, but throughout the year, you're expected to put in a contribution, and then you would, of course, settle up at the time of filing. So just get used to it. It is what it is. That's another area of responsibility that you got to be prepared to just take on. You also, of course, will have to understand what appropriate forms need to be filed. Again, that's where you're relying on your accountant or your tax advisor. Another thing you've got to also handle are keeping up with those customary deductions. You've got to have a system, your receipts, those expenditures, your mileage, things along those lines. If you're not billing that back to the client, it's going to be potentially deductible, but you've got to have good records. So this is more responsibility that you've got to think about in terms of starting your own firm. One of the critical pieces of this presentation is, of course, thoughts about finding clients. When I started out, quite honestly, I was, like I said, I had the safety net of the public defender's office. Other than, of course, my real estate world, I didn't have a way to say, okay, I know I'm going to exactly have business coming my way. So I like to, throw things out. Some people call it the universe. I'm a woman of faith, but I believe in asking for what you want. And expecting those good things to come your way. So I, of course, prayed about it. Please, send me good clients that respect lawyers, of course, honor the attorney-client relationship, want to pay their bill, want to honor their obligation, of course, because there's nothing worse than you're doing the work and then you've got a client that somehow, whether it's hard times or just, not being honest and of integrity and dishonoring their obligations, but it can happen regrettably. So I believed in, initially, and I still do, the kind of clients that I want, that I'm compatible with in terms of my personality, the issues, let me be able to help them, let them value my services. So I highly recommend starting there first and foremost. But of course, we're in the real world. You're gonna let your classmates know. You're gonna let your colleagues know that you're now on your own or you're starting a firm. You're gonna reach out to your professional contacts. So your dentist, your accountant, your doctor. You're going to let everyone who you do business with and support in their practice know I'm now on my own. And of course, you're going to have business cards and you're going to present the business cards so they can think of you. You're going to let them know what you're doing. You want to get to the point, it's really neat. When I spoke with Dean Fitzpatrick, where she said she had sent a potential real estate client to me a little while ago. And it's a good illustration of the fact that you want to be able to, when someone says that particular matter, you want to immediately pop up in someone's mind and say, Clotel, real estate. Now Dean Fitzpatrick knows that I actually no longer handle real estate matters. But I hope down the road, I will have planted enough seeds for other business down the road that's more in line with what I do. You want to be able to be front and center in someone's mind when you're out on your own, that these are the matters that you handle, and they should call you and send the business your way. You're also going to want to take advantage of the court systems framework for assigned counsel appointments. Okay, so you're going to seek court appointments as permitted under law. As I touched on earlier in my practice, I do Article 81 mental hygiene work, and so there are appointments there where the judge, you've appeared before the judge, you've taken the continuing legal educational course that allows you to be now certified to be able to take these assignments. boom, next thing you know, in your inbox, you get an alert. Judge so-and-so has now appointed you to represent a party in this matter. And of course, you're entitled to bill and get your fees. That's the court directing business your way. If you're handling indigent defense matters like assigned counsel, public defender work, where you're not working in a public defender office, but when they have conflicts, you're taking on cases that they can't handle, you're again assigned and on an approved panel. Guess what? You're on that panel, phone call, email, what have you, the court has now directed you to take a case. And you get to, of course, bill at the structured rate, but it's still income coming in, and it's work that you've not had to do in order to get that client, except for the upfront work of getting on those panels. And that's typically an application, and then guess what? You're good to go. There could be a CLE or something along those lines, but it's a day's worth of work, and now you're on that panel for an extended period of time, and the work is coming your way. I also highly recommend that you consider joining the New York State Bar Association's Lawyer Referral and Information Service, LRIS is the acronym. And that is another way that you're going to get referrals as a member. I think it's $75 annually. And now you're giving them your specialties, and you're in a list of approved attorneys that if it's an estate matter, if it's a vehicle and traffic matter, whatever you're doing, you're now a part of that network. And of course, once again, you're going to get an alert. Ms. Drakeford, Clotel, so-and-so client has contacted the Bar Association. This matter has been referred to you. Also, similarly, under that kind of framework, all of your typically local county bar associations or your specialty bar associations, your women bar associations, etc. They usually also have a similar system of referrals. It's a benefit of being a member. You should be networking as well. So through those associations, you're networking and you're getting a stream of client referrals that, again, you're not having to invest but so much time in order to generate that client business and revenue. I touched on it already, so I'm not going to harp on it, but you should know that if you're on your own, you've got to have relationships. You've got to be networking. You've got to be attending our alumni events. You've got to be attending your local county bar association, and you've got to also get outside of your circle. And you can, if your practice, let's say it's estate planning, you need to be going to some of those financial planners, those advisor events as well, and have your business cards and be ready to follow up with lunch or other meetings to build relationships for business. If you're sending business to a certain individual, there's no obligation for them to send business back to you, but typically if people work well together and they have a respect for your work ethic and the way you conduct yourself, usually they're going to want to drive some business your way because they are comfortable with the fact that they're getting their client a quality referral and a quality outcome. So you want to build on those relationships. You can, of course, start advertising. So this is free if you create your LinkedIn page and update it and update your profile, which I need to do as well, and also create your own independent standalone Facebook page. I'm now moving into that more prominent presence. I initially didn't really feel the need to really advertise and hold myself out via social media. I had so much work. At one point, I just didn't focus on that. Things have slowed down considerably now. And we're, of course, transitioning somewhat, I think, permanently into more of a virtual or online engagement as a result of just convenience, I think, and being more effective in how we can use our time in dealing with clients. So I think now it's right. The time is right for me to evolve and drum up business that way. So you should certainly be thinking about it. And if you've already kind of created that profile, build on what you have. You could, of course, establish a website. And I know that for some people that seems like a daunting task, but there's actually a company called GoSmallBiz.com, which allows for you to have a membership, and it's a business reference resource. I just signed up myself, and it allows for you to establish a 5-page website. It's like a $35 per month membership, but it gives you that tool along with other important things. Let's say you're dealing with human resources, or you need kind of some guidance on handling, a copier issue. It's a reference kind of database for all sorts of business related issues. So you can create a website that way if you're not techie like myself. Or you can, of course, spend bigger dollars and arrange for a professional to create a website. I did price that, and it was a couple of $1,000s earlier in the year, and I thought, not yet, don't want to make that kind of investment right now, but later on down the road, absolutely I would. A lot of people are blogging, so that's certainly a way to create, new client relationships. And you can, of course, do online advertising via Google, other sites. You also can do the old-fashioned, just get the yellow pages sort of arrangement as well. Now we're going to move into tips for developing a business and marketing plan. And this is absolutely important and critical. It's going to provide you a roadmap, and it should hopefully also create a vision for what you want to see happen in starting your practice. So I point out initially, failing to plan is planning to fail, plain and simple. You can wing it, you can have a little throw together, get out and I've got cards, I'm just gonna let people know that I'm practicing on my own. Now, you can absolutely do that. However, you may not see income coming in, or you may find yourself, running amok because you don't have that infrastructure. So definitely plan to create a business plan. You ought to be thinking about, will your practice be transactional in nature, like we touched on earlier? Will it be more of an advice and counsel sort of role? Will it be a mixed bag? Are you litigating? All those things you should be thinking about, because of course you're going to have to be able to project how much revenue you're going to need to be able to generate in order to be profitable. You're going to want to understand, am I billing by the hour? Am I going to have a kind of a flat fee arrangement, or again, a combined approach? You're going to need to set an hourly rate, of course, and understand what your peers are charging in your local area for your practice specialties. So you got to do some research and understand, if a practitioner who's been, operating for 20 years or 30 years is charging X, and you're newly admitted and, 2 or 3 years out, you probably want to be competitive, and you want to also leverage the fact that you could probably do the work for a little bit less, but you're going to do a great job, and you're not going to expect to command the kind of rate that someone who has years of experience and credentials in comparison to where you are in your practice. You're going to also want to figure out, where will you practice law? Are you going to go across the entire state? Are you going to go regionally, New York City, metro New York area, upstate, of course, capital region, combined? You really need to figure that out. Where's your office going to be? You need to be thinking about that. Are you going to practice out of your living room? Okay, fine. That people do it. We're all in this virtual world. I've taken files home. I'm in my office now, but I could have appeared in my living room. It happens. This is what we're dealing with right now. But as we transition, hopefully in the next year or so, back to somewhat of a traditional practice, you're going to want to have a suitable place to host and meet with clients or opposing counsel, depending on even if it's a closing, you're going to need a conference room, things along those lines. So you got to be thinking about, if you're going to right now start out very modestly and operate out of your home, but you're going to be prepared to meet with the clients once we're no longer in this virtual world, you're not going to want to bring a client to a Starbucks. You're not going to want to be at Panera Bread, depending on the nature of the issues, the confidentiality piece of that, the distractions, or you may need space to review documents and go over things. That little area is not going to probably work out, and it certainly doesn't establish professionalism. So all of these things you need to be pricing, understanding in advance what's the going rate for rent in office spaces in your area. You can call, there's listings, or online, but you need to be projecting and understanding what likely you're going to have to spend if you do get an office space. Or if you're going to take advantage of, like in the city, they've got WeWorks, things like that, where it's a membership, but you can go in for a specific matter. You need to understand what is the cost for doing business in that way. And of course, we touched on, where will you be appearing in your matters. Another important consideration is, you need to understand your ongoing operational costs for supplies, equipment, software, and various services. So I bill by the hour as an example. I need a billing system, okay? I cannot spend my time handwriting or typing up an invoice. I have a billing coordinator now who does all of I do timesheets, and then she enters the timesheets into a billing system that generates the invoice, and of course tallies up all of my time, does the math, does the computations for me, and then of course if there's a calendaring system, once the invoice goes out, it tracks it for the 30-day due date. If I have a slow pay client, of course, interest now is being calculated as well. So you've got to subscribe or purchase some sort of software or service that allows for the convenience of these sort of capabilities. So you need to understand what those costs are going to be. I have a monthly fee for my billing, and it's $62 a month. But I should be able to understand over the year, what is that going to cost me? As an example, of course, if you're in my kind of practice, and I'm not sure of any practice really where you don't need a printer, you don't need copying capabilities, you may need faxing capabilities. You've got to get equipment. You know, in my office, of course, I have a workspace, I have a desk, and then I have, of course, another desk where I can spread documents out. You've got to buy office furniture. You need to be pricing all of that. The bookshelf, your law library, what have you, other reference materials that you may need, your Westlaw. All of this you should be factoring in and budgeting and contemplating in advance. Of course, we've talked about the expenses. You've got to have some kind of a makeshift, even if it's just bare bones, bookkeeping system, unless you're going to be in a position to fortunately immediately outsource that responsibility and hire a bookkeeper who's going to come in and keep the books for you monthly or weekly or however you want to structure it. But if it's just you starting out like I did, you're it. So you've got to be able to have a system for tracking what your receivables are, meaning what you billed, what you've got, you know, in the pipeline for a customer or a client, excuse me, to pay you, or of course, you've got to understand what are your expenditures. So you've got to have some sort of system in dealing with that and tracking that. You also need to understand the time and the cost involved for marketing your services. So, you know, if you are going to take advantage of let's say, like I talked about, let's say you're beefing up a Facebook profile, let's say you're doing your LinkedIn, or you're going that extra step like I'm about to do, and you're going to create a website taking advantage of the Go Small Biz. That's time away from practice. Anytime that you're doing administrative or operational related activities, you're not working as an attorney, you're not looking at client matters, you're not billing, you're not generating revenue and income for yourself, i.e. your practice. So you really need to be able to allocate appropriately per week what would be a good way to achieve that goal, but at the same time, make sure if you've set for yourself some billable hour, you know, standards, no less, I've got to bill 30, 40 hours, whatever it is per week, you got to be able to factor in the time that it's going to take for you to also continue to market and drum up business. You also need to create a system for follow-up on client referrals and new business development. Again, you want to keep client business in the pipeline. So sometimes the timing isn't right to take on a matter for a client. In my guardianship practice, I've had prospective clients to approach me and say, Clotel, you know, mom is getting up in years and we're worried about her, but she's still at home. She's still doing okay. But we know at some point, we're probably going to want to need to, you know, we're going to need to file for guardianship for her. And we're going to need to structure it in a way that she can be happy and we can be happy. Guess what? That is future business. What I'm going to do is take, of course, the prospective client's information. I'm going to make sure that I keep in touch, that I follow up. If there's a development in the law or some sort of event that's relevant to that prospective client, I may reach out. I may touch base and say, hey, by the way, this just happened, you know, in this jurisdiction. How's everything with mom? You guys are still okay? You've got to make sure that you're always thinking about future work to keep things, again, in a quote unquote pipeline kind of mindset. Now, the startup costs and the timing for hanging out your shingle. I would hopefully tell you, you know, that in the perfect world, 6 months is really the most, I think, reasonable way to go. But I understand some people, they decide, I can do this. I believe in myself. I can get out there, and they go, go it alone with, maybe 30 days or 2 months of reserves. You can do that depending on your practice. There are ways where you can handle matters quickly, V&T, vehicle and traffic, what have you, and start to generate quick cash. But it's very stressful to take on that approach when you're on your own. So I would caution that, just for your peace of mind and being able to sleep at night, that you do your best if you can to plan and strategize and have at least 6 months. So when we've done our business plan, we now have a projection, right, of what, of course, we anticipate our expenses are. So for instance, my office rent, let's just make up a figure, it's $600 a month. We're making that up, that's not the rate. But I would want to have, if I called in advance and investigated, I want to know right now, I have $3,600 in my operational account, so that no questions asked. If nothing comes in the door, I'm waiting to get paid on something, I've got enough reserves to be able to cover my office expense, right? And of course, that's just bare bones, but you got to think about your other office overhead expenditures, like your phone line, etc. Don't lose sight of the fact that you're still responsible for covering your personal obligations, such as, of course, your own housing, or if you're like me, you may have student loan debt. So those bills are still going to come due. You're no longer working for someone where you can rely on that structured, lovely paycheck every 2 weeks or every other week or what have you. So now you're it. And so you want to make sure that you've got enough reserves for your personal obligations as well as for your professional obligations. You can, of course, explore lines of credit and personal loans or professional loans. Typically, if you're just starting out in terms of business loans, you usually need to have some history, whether it's just having, of course, your internet service. Most lenders are not prepared, unless it's a very small loan, to make an extended loan for a large amount when you're just starting out. So personal loans probably very easy to do, along with lines of credit. You can explore that, but again, keep in mind that you must consistently generate enough revenue to create cash flow to honor any repayment obligations. So if you take advantage of that $10,000 loan, and they say, oh, you don't have to worry about any payments until 60 days out, you got to start repaying it. Guess what? You need to have, if you invested in that $10,000, you've purchased your office equipment, you've got a part-time, bookkeeper for your books. Whatever you've invested that money in, now you've got to be able to make sure that you have generated some cash, or you have allocated enough cash to start honoring the note so that you don't obviously affect your credit standing. So I want to offer some final tidbits of advice, and I hope it's abundantly clear that starting your own firm is a huge leap of faith. And I say that because you're actually, when you take a position at someone else's firm, also taking a step of faith. You're trusting that the employer is going to pay you as they said they were going to pay you, that everything essentially is on the up and up. You can work there, it's all going to work out. There's some time that has to be established, evidence and time, that what you thought was going to happen, in fact, is going to happen. And that's where that faith component comes in. Now, before I went to law school, I actually was a legal assistant for a number of years. I'm sure that was not on my bio. I don't put that on there now. But I had a paycheck or two to bounce working for a personal injury plaintiff firm. Okay, so it happens, regrettably, for some practitioners. Things get tight, especially if you're in a contingency sort of practice. So I was an employee, and I believe my employer could honor, his obligations. He made it right, but things happen. So you've got to be able to have the next point, confidence. You have to have faith in yourself. You've got to believe in yourself. You've got to believe in the value of your education. You are typically the expert in the room when you're with your clients. Sometimes your clients are super savvy, but most of the time, depending on those issues that you're handling, you're it. You're the expert. You have the training. You've taken the bar. You've passed it. You've successfully graduated. You have to own your right to feel accomplished and capable. And as women, there's a syndrome I've heard of recently called Imposter Syndrome. We don't believe that, we're deserving of success, or, how can we, even aspire to go to certain heights or levels. We have to reject that. We are entitled to go after our desires and our goals. We've worked hard, we've gotten this far. And so you have to believe that you have the abilities, the skill sets, and the gifts in the practice of law to be profitable if you do decide to go out on your own. And guess what? That's what your employer is doing every day. They believed in themselves, and they felt they had what it took in order to hang out a shingle and get a practice off the ground. You can do it too if you choose. It's hard work, but if you're patient and disciplined, you will be successful. One thing I also want to make sure that I reiterate, it is better to say no. It is better to decline a matter if you're not competent enough to handle it, of course, in accordance with the governing rules of professional conduct and responsibility, or if you can't associate. If you can't bring in another more experienced attorney to be co-counsel with you or oversee the work, say no. Turn the client down, and do it, of course, in a way that is respectful, but forthcoming. This is not my area of specialty. I wish I could help you, but it's not something that I handle. I would like to, if I can, refer you to the New York State Bar Association or the County Bar Association, but this is not my area. Example for me would be someone calls me on a bankruptcy matter. Don't handle it. I'm not going to do it. I'm going to direct the client somewhere else. And if you're too busy, it is in your wheelhouse. It is right up your alley. But guess what? You're swamped. You've got a lot of deadlines. You've got a lot of things going on. Turn it down. Don't lead the client on. Don't string the client on. Don't do a shoddy job. Be mindful of your reputation. Be mindful of, again, your standing in your practice. You also have to maintain, as much as possible, a reasonable work-life balance for yourself, for your family, and of course your clients. I learned this the hard way, because when you're on your own and you're doing the bookkeeping, and in my case, I'm the legal assistant, so I'm making the copies per se. I'm now at a point of looking for part-time support there. I have a billing coordinator, and I'm taking the next little leap of faith to administrative support. But if you're the one that's doing it, you're going to be stretched and pulled and many times in multiple directions, and it leaves you depleted. So in my case, I am a single woman currently, and I don't have children. So I don't have to worry about those pressures and how it can impact a family or a relationship. But those are things that you do have to be considerate of course. You can't turn away from your responsibilities, but at the same time, you can allocate time, plan and strategize, and go ahead and take that vacation. Oh boy, it looks like I apologize. It looks like my cord needs to be pushed into the outlet, so I'm going to step away for a quick second to ensure that you don't lose me. I got a battery low alert. Excuse me. So you want to make sure that you're mindful of work-life balance. Lawyers are constantly billing. It's our responsibility for working at a firm, but you need to be able to keep up with the volume of work, but also prioritize your personal happiness and needs. And also, when you get to that point that you're feeling squeezed to no end and you have a ton of work, or your operational responsibilities of your firm are really getting overwhelming and you really feel like you can't handle it, it is time to hire an assistant. It's time to take that next step of faith and say, I can pay this person, I can generate enough money, and they're going to save me some time, and I can actually be more productive because I'm focusing on providing the legal services. So I hope that I have covered a lot of ground, even though we got off to a little bit of a late start, and I couldn't tell whether there were questions that were already kind of going in the chat, but I'm happy to take some questions.
Thank you so much, Clotel. So I don't see any questions in the chat, but what I do, and you covered so much material that I would imagine there are some questions out there. So I encourage our participants to go ahead and unmute and or raise your hand if you're more comfortable doing that, and ask away.
Dean Fitzpatrick. I don't have a question, but I would love to say hello to Clotel before I have. Clotel, I have to go to another meeting, but that was great. Such great information and advice, and it's so good to see you, and it's so nice to see how successful you are. I had no surprise. You were always a star, and such a great presentation. So thank you for taking the time, and I hope we can catch up soon.
Absolutely, Dean Queen, and so wonderful to see you. I send you a big, warm hug.
Big hug. Right back at you.
Thank you.
Bye. Thank you.
I
I
see.
have a couple of questions. I don't know if other people do. Hi, thank you so much for sharing your time today and your experiences. I have a few questions just kind of starting out. So you said you were in the public defender's office starting. How long did you do that before you decided to go out on your own as a sole proprietor first?
Okay, so that was out of the gate. May I call you Elizabeth?
Yes, please.
Okay, Elizabeth, that was right out of the gate because it was a part-time position. So I only worked, 30 to 35 hours a week. I had a fixed salary. I was fortunate enough to have health care and dental benefits. I was a part-time county employee, but it was a fixed salary. I'll tell you, it was just under $50,000. I've got student loan debt. I've got, cost of living expenditures. I felt for, of course, my experience and my education that I needed to get out there and supplement my income and generate more work. So I wrapped my solo practice around that part-time opportunity.
Great, okay. And from there, when you started being a sole proprietor, when did you decide, how long did you do that before you did PLLC?
I formed the PLLC in 2017. I started out at the public defender's office in 2013. I did take a position as an associate for almost 2 years at a firm called Rapport Myers in Columbia County. So there was a break in that solo practice status. So I would say 2 years initially with the public defender. I worked as an associate at a firm, and then I left that firm in the fall of 2016. And in 2017, I formed the PLLC, and I've been on my own in that capacity since.
Okay, so you're about a year out on your own before you did the PLLC? Completely on your own, I mean, outside of
Yeah, that's about right. Correct.
Okay. Interesting.
All right.
How do you handle clients that don't pay the bill?
That's the worst nightmare, especially if you are a solo.
Right.
You have to follow up. And thankfully, I've had some slow pays. I have yet to have a staunch refusal. So you've got to be diligent. You should have already, if you have a billing system, which you should have already have it calendared and, like a tickler system where the system itself is tracking the due date, right? So you should be mindful when your bills are due and when payment should have come in. And I usually give it a few days. And then if I haven't received payment, I send out, of course, a subsequent invoice. So you're going to keep invoicing. You're going to follow up with the client and understand what's going on. I've had a few instances where the client will tell me, I don't have it right now. I'll have it X date. And thankfully, they've honored that commitment. But one thing that you can do, Elizabeth, in your retainer agreement is in the event that a client fails to pay, you can structure it that you reserve the right to stop representation until the matter is resolved. So it's an upfront agreement that they're waiving, a right to kind of, especially if there's work that the quality of the work or what was done, there's no dispute. You've done the work, a fee is owed, they're just not able to pay. And so I have had the privilege to withdraw from a criminal matter where the client had agreed to pay X dollars. That time came and went. And guess what? They're not coming through with what they promised. I promptly, based on our retainer agreement, brought a motion to withdraw. That motion was granted. And thankfully, you have to be careful there because depending on where you are, what stage you are in the case, some judges will not grant that, irrespective of what the agreement is. But this, thankfully, was at the beginning stage of the matter. We did some initial workup in the case, and then there was an expectation that the retainer would be supplemented. And then I started getting the song and the dance, and I promptly withdrew before I was on the hook from the court's perspective.
Great. Well, I will let other people
Hey,
ask any questions if anyone has any. Thank you so much. I really appreciate your insights.
You're welcome. The one thing I want to really stress, you want to make sure that you set a fairly reasonable but somewhat, I want to say aggressive, but a firm retainer. So usually my minimum is a $2,500 retainer, because if the client has difficulty presenting the $2,500 up front, they very well may have limited capacity to supplement and do other things down the road. So you have to gauge what you think is reasonable and what you think is fair, but you have to think about the complexity of what you're doing, what it's going to take to get the work done and reach that retainer. But that's at least one way where you've got the client does have some skin in the game, and they've come forward with that initial money, and you can kind of gauge from there what their capacity is to pay.
Great. Right. Thank you.
That's great advice, Clotel. I realize we're a little short on time, but we do have one hand raised.
I'm here because I thought it was at 1, so I'm available if someone needs to, go ahead and ask the question.
Okay, go ahead, Doris.
Hi, thank you for this talk. It was really informative. I have 2 questions. The first being, I know you practiced in the private sector for a couple of years, as you mentioned. So what was it that made you ultimately leave and decide that that wasn't for you and that you knew you wanted to start your own firm? Was it the autonomy, or what led you to that?
That's an outstanding question. I felt, not that yours wasn't either, Elizabeth, but it's a very poignant question, because it kind of gives you insight to my personality and my thinking and thought process in this. I had already worked for attorneys before law school, so I kind of, and like I said, I had an attorney to not be able to pay me, so I'd seen kind of the highs and lows, and then and fast forward like a year later, he had a huge, jury verdict and of a 7-figure range. So it was kind of feast or famine at times. So I'd already experienced some of those highs and lows of being at a firm just as an assistant. And then, of course, in law school, I worked through law school, and I took on a sales position as a realtor. So I was in sales, selling, but I was my own boss, setting my hours and handling matters around, of course, my obligations as a law student. So I already kind of had this entrepreneurial mindset, if you will, in spirit. And so when I took the public defender position, having that control, having the ability, to honor my commitment again in that office, but still drum up and test the waters and the boundaries of what I could generate and earn on my own was really appealing to me. So when I was lured into private practice as an associate, at first, it really seemed, really appealing and nice, because, I had that safety net. I had that structure in terms of, okay, I don't have to do as much work to try to drum up business. Although, of course, if you're an associate at a firm, at some point, there are expectations that you're going to be bringing in, client work, and of course, contributing to the, the pipeline of business to keep the firm profitable. But initially, it was a lot of book of business that the firm already maintained, and I was kind of taking on some of those employer clients, and things were going really well. But having to, report at a set window of time, office hours or 9 to 5, and it wasn't well, you can take some time and work from home and still, meet your billable hours. It was, we want you front and center. We want this, make sure that we can see what you're doing, sort of thing. And for me, that I'd like to have some autonomy, where if I decide I'd like to draft a brief from home, not have to come into the office, I want to be in my pajamas, or I want to be in my sweats. I want the freedom to still deliver the work product, but on my terms. And so I just felt kind of squeezed, if you will, and I felt restrained. I also couldn't handle certain matters that I wanted to handle. That was really the bigger sticking point. So I had to give up the criminal defense work, because the partner who recruited me was actually a part-time assistant district attorney. And so there was an appearance of course, a conflict of interest if I continue to take those criminal matters. And so those restraints on my practice, this is what the firm did. You have to really stay within, that wheelhouse. And so I wanted more liberty and more freedom, if you will. And so I opted about 2 years later to step away and take a leap of faith in going out on my own full time.
Yeah, and a follow-up to that. I know you mentioned that you worked as a legal assistant before you went to law school. So would you say that having that experience from basically working at, more like the administrative kind of beginning steps of a case to, now working as an actual attorney helped you in how you managed a case starting in?
Absolutely. One thing for sure, you know exactly how your end product, what the format, how the documents should of course be presented. You're already thinking about how many copies, how many sets, if you're in a case where you've got, multiple parties to the matter. You're hardwired for what has to be done to get it, copied, covered, and sent out. So all of that administrative stuff, I was at first really comfortable with just tackling it and getting it done. But as I said, the time that you spend running those copies through the copy machine, printing the envelopes, stuffing, running to the post office, you're not billing. You can't bill a client for that, right? So, my hourly rate is fairly sizable in comparison to what I would pay an admin to do that work. I can't bill. I'm eating that time. So yeah, I definitely think it is a little bit of a cold comfort, if you will, that you have those administrative skill sets. But at some point, you've got to be able to give up that control and that in your mind little safety net and trust someone. That's where I am now, who can step in and do a good job and train them as needed for your practice and what you require for the work, the end product and your work product. But you got to, at some point, it's almost like what I say, a little umbilical cord. You've got to cut the cord. You've got to be the lawyer and allow someone else to support you and provide that administrative assistance.
Thank you. And then last question.
Like I said, I thought this was at one.
So I know that in the beginning, if you start off as an associate, you get work filtered to you. And like you mentioned earlier, at some point, you need to start building your own book of business to be a vital part of the company and obviously eventually move up. So would you say to follow kind of the marketing structure for an entrepreneur? Is it a similar structure you follow when you try to gain a book of business?
Absolutely. So this I would argue respectfully would be your partner track. This is what you should, if you want to start thinking about partnership at a firm as an associate, there's got to be an entrepreneurial mindset that you're going to also be a rainmaker and you're going to bring in business. So yes, all the things that I talked about, absolutely, it's transferable, in my humble opinion, to contributing to the vitality of a firm in order to move up the ranks from associate on to the partnership. And of course, you should be honest with, your partner saying, hey, I really feel like this is a good fit. I see myself having, a good, potentially long career here. Of course, in the back of my mind, thinking about partner, what are your thoughts? Get the feelers out there and then start to deliver on what you believe is a possibility in the relationship. No attorney, if it's a good case and a good client, superior attorney is going to be upset that you're being assertive and bringing in good clients and good work to the firm. It's going to be absolutely embraced and welcomed, and you'll start to see more assignments or more opportunities coming your way.
Thank you so much.
You got it.
So Clotel, there's one question here in the chat before we leave, and it is, how much roughly is a malpractice policy for someone who is 10 years in practice, if you know?
Okay, so I meant if I had the extra hour that I thought I had, I meant to pull my policy out because I knew someone was going to ask me a question like that. I'm 7 years in now. And so I would say I have $1 million policy, of course, to cover if there were, God forbid, multiple. I don't expect to ever have, at this stage of my practice, to have, created a situation where damages or that much in one suit. But if in case there happened to be multiple claims. And I think for the $1 million that I have, my premiums, I think my policy is about $2,000. And of course I did half of it up front, and then you can structure out your payment. You can break it up 3 months, you can break it up 6 months, or you can do it all in full. And so I like to, if I can, knock out half up front, and then of course have reserves. I always want to keep something in, you know, in my operational account in case something unexpected happens. I've got to buy a new copier or what have you. So I then broke it up into smaller payments, and my payments are like 2 something per month from there. So I would say it would probably be somewhere in there, give or take, up a little bit more, maybe 25, whatever. But it can be, again, worked out in a way that you don't feel like, oh my gosh, I've got to pony up, you know, $2,500 right up front out of the gate. They will allow you to structure it. And a plug-in again for the state bar, I highly recommend. I'm using the group benefit discount through, I can't think of the name. I think my company is Cigna. I would pull it. I'll follow up on that, but it's through the, not Cigna, that's medical. CNA, excuse me. And they allow us through our membership to get a group discounted rate. So my health insurance, my dental insurance is through the New York State Bar Association because we all get the pooled benefit of a discounted rate. You can certainly shop around and get a competing quote, you know, from other providers, but I just took advantage of what the services are offered for the State Bar members.
Terrific, terrific. Well, thank you. So, Clotel, thank you so much. I mean,
My pleasure, my privilege, and my honor.
you are fabulous, and it's such a joy to be in your presence. So I cannot thank you enough. I'm so sorry for our snafu, but you know, as a testament to your remarkable agility, here you are as ever. So thank you so much, and thank you all for joining us this afternoon for what has been an incredibly informative session.
If there are follow-up questions, you're welcome to email me at cloteldrakeford@gmail.com. No dots, no dashes, no underscores, just my first and last name @gmail.com. I hope to, I actually, because I started so late, decided not to go into this checklist, but I really want you to lay eyes on it. And if there are some follow-up questions that may arise after you look at it, don't hesitate to email me or give me a call, and we'll carve out some time. You've caught me at the best time. My practice has kind of slowed down quite a bit with what we're dealing with in our state and globally. So I've got a little bit more time in my hands than I ever thought that I would right now. And I'm happy to help a colleague, and especially Albany Law, of course, alum, so, or students. So please don't hesitate. Just give me a couple of, you know, a day or so or hours to follow up, but I will.
Thank you so much for your generosity, Clotel. Be well, and we'll talk to you soon.
Stay healthy and safe, everybody.
You too.
Bye-bye.